Okay. Hello, everyone. I want to welcome you to this CLE program on QDROs, Qualified Domestic Relation. No, what was it again? Well, we'll learn what it is.
Qualified Domestic Relations Order.
Relations orders. Okay, there we go. So, as you see, this program is being recorded. And there will be 3 codes during the program. So be sure to pay attention to the codes, write them on your attorney attendance form, and send that to me at barbara@rocklandbar.org. Send that and the evaluation to me as soon as you are able to. I just want to let you know some upcoming programs that we have. We have several programs in the works that don't have dates, but the ones that do have dates include March 13th, a program on foreclosure, April 19th, a program on estate practice, and May 10th, the annual program we have on the CPLR update. So for this program, if you have questions, please put them in the chat, and Jay will get them during an appropriate time. So please remember to mute yourself unless there's a reason that you're speaking. And I'm now going to turn it over to Jim Sexton to introduce the speaker.
Thanks, Barbara. Hi, everybody. Nice to see everyone. I apologize. I'm in COVID exile. I managed to go 3+ years without it, and now I've caught it twice within 90 days. So I apologize, but I'm not wearing my lawyer costume. I will be uncharacteristically brief. We have the pleasure today of having Jay Mota with us. And what I want to say about Jay, for those of you who don't know him or haven't worked with him before, is he's a guy who puts me to sleep. And I don't mean that in the sense that what he's going over is boring, although tax stuff has never been the most compelling things that matrimonial attorneys work on. I mean that he actually allows me to sleep well at night, because messing up a QDRO, messing up retirement provisions in a stipulation of settlement, that is among the most potentially costly divorce mistake a person could make. It is the kind of thing divorce lawyers, if you're not afraid of it, it just means you don't understand your exposure. Because when you're calculating what your malpractice coverage should be, when you start to look at what the numbers would be in the event you make an error on a qualified domestic relations order or any division of retirement assets, you get into numbers that just become absolutely silly. So having someone like Jay as a resource for us as a bar and as matrimonial practitioners is a real treasure. I know my experience of Jay has been that he works with clients of mine. He's worked with my firm, and he's always just somebody who's accessible and reachable with questions about these kinds of issues. I'd love to say that even experienced matrimonial practitioners who have good people like Jay and other QDRO drafting services that are out there, and QDRO drafting people that are out there, that if we have that, we can just go, okay, we're just going to put in the provision in the stip that says, the party's retirement assets will be divided with the Majowskis formula, and we're going to let Steve Abel, or we're going to let Jay Mota, or we're going to let Tova do it. But the truth is, the provisions we put in the stipulation, there's a bounty of appellate division case law that talks about how we are constrained by the specifics of the language in our stipulations. So just punting after and saying, okay, we're going to retain someone to help us draft the QDRO, it's not the shelter that we wish it was. It's not the safety that we wish it was. So a program like this one is a real resource for all of us. So I'm excited to participate in it and to learn from Jay, who really is a master of the craft. His bio has actually been provided to you electronically, so I won't bore you with all the details, but Jay is a certified divorce financial analyst, a certified financial planner. Those are two credentials that those of us who worked with professionals of this kind know. It's not an easy thing to get. To become a CFP requires a tremendous amount, not only of training, but also experience and testing. He's a chartered financial consultant, a wealth management certified professional, a certified QDRO specialist, he's a candidate for a master analyst in financial forensics. He's a trained family mediator, a collaborative law professional. He's got smooth dance moves, and once he sings a song, it's eternally his. Jay is a pleasure, and I'm I'm thrilled to hand over the microphone to him. And at the end of this, if you have questions all along, rather than interrupting, we'd ask that everybody stay muted. And just put in the chat. There's a chat box. If you go down on Teams to where it says chat, it's next to the participant box. Just click that. If you have a question for Jay anywhere along the way, just put it in the chat. And then at the end, we've reserved some time where I'm going to moderate some of those questions, and Jay's going to be generous with giving his time and giving some answers. So without further ado, I will shut up and let you speak to the man of the hour, Jay Mota.
Thank you very much, Jim. Jim did a great job in introducing me, although I think he lied to all of you because I don't know how to dance. But other than that, I try my best with 2 left feet. I ask you all for forgiveness in advance. Jim mentioned that he's in COVID isolation. I myself am struggling with some sort of bug, flu, or whatnot. So I'm going to do my best to get through this and answer everybody's questions. This is an area which I am very passionate about, not only because, it's not about drafting the order and effectuating the order and getting the alternate payee the money they deserve in the equitable distribution, but it's more so the work that gets put into this prior to the order even being, looked at or to be drafted. And what I hope to get out of today's CLE is that you understand the need to start this process very early on in the proceedings. So getting this started is going to give you a lot of the information you need so that when it gets to the point of drafting the actual orders, it's pretty easy. So obviously we're talking about retirement plans. And in the land of domestic relations orders, when we talk about retirement plan, you talk about qualified, non-qualified, tax advantage. Depending on who you're speaking to, this can be interpreted different ways. But in the land of domestic relations orders, you have qualified plans, non-qualified plans, and tax advantage plans. And it's important that you understand what type of plan you're dealing with, especially when it comes to regulation. So you have different regulating authorities over different plans. You have ERISA, which is the Employee Retirement Income Security Act of 1974. This governs all private plans. Now, a private plan can be a publicly traded company or the business down the street, but it's a private plan. Your public plans, such as your federal and state plans, are not covered under ERISA. So we don't want to cite an ERISA regulation under a federal state plan because it's not going to get accepted. And then your private plans, such as individual retirement accounts, IRAs, Roth IRAs, simple IRAs, and SEP IRAs. Now, that can be a bit confusing because simple IRAs and SEP IRAs are generally offered through an employer, but they're not considered a private or a public plan. They're considered an individual plan. So let's talk about qualified plans. As I mentioned, a plan is qualified when it's covered through ERISA and it's private. So when you think about a qualified domestic relations order, what you're talking about is a domestic relations order for a qualified plan. Now, I know that we use QDRO for all types of plans because everybody, thinks about the orders as QDRO. But it could be a QDRO, it can be a DRO, it can be a COAP, a court order acceptable processing, it could be a military DRO. There's so many different legal names for the type of orders to be drafted, but it's specific to the plan. So when you're talking about qualified plans, we're talking specifically about private plans that are governed through ERISA. These, again, require the use of a QDRO, and they'll cover pensions, although we don't see too many private pensions out there, but they do exist. But your other accounts are like your 401ks and the like. Non-qualified plans, such as your state and federal plans, you see these for education, public safety, government employees. These all require a DRO or domestic relations order. And a lot of these plans will have pensions, but they'll also have the TSPs, the tax sheltered plans. the 457s, the 401As, the 403Bs, etc. Plans that are covered under here, the federal employee retirement, civil service retirement, military. I haven't really seen any railroad employees, but railroads covered under here. More locally, the New York State local retirement system, the New York City employee retirement system, the New York State teachers retirement system, all of those plans are non-qualified plans. So they're not covered under ERISA, and they kind of make their own rules. And that's important to know. But these all require some form of DRO, domestic relations order. Your tax advantage plans, these are individually owned accounts. So your traditional and your Roth IRAs, your employee simple and SEP IRAs, and almost always is a DRO not required. So oftentimes I'll see a settlement agreement and I'll have a list of retirement accounts. And in the settlement agreement, it says that the IRA is to be divided by, a QDRO or a domestic relations order. And that's not necessary. It can be done, but it really is overkill when it comes to what's necessary to do that. These accounts transfer incident to the divorce, meaning that simply with the divorce decree, a letter of intent from both parties, and then each custodian, your Fidelities, all your Schwabs, your JP Morgans, they all have specific ways to divide these plans. Oftentimes, it's a letter of intent from both parties, a copy of the domestic, the settlement agreement, and a form that they have to transfer the account so that it gets transferred accordingly. The one thing I'll say about these that are annoying is that in order for them to transfer them, typically the alternate payee or their spouse receiving the other spouse's benefits has to open an account with that firm. So they may have to open up a separate IRA at that firm before ultimately moving it to their own IRA somewhere. But it does not require a domestic relations order. And if they want it done, they're going to pay an extra, $700 to have it done, which doesn't need to be done. So we talked about whether you have qualified, non-qualified, or tax advantage plans. But now, and we described how those differ. Here we're going to talk about different types of retirement accounts, and why this is important you understand is to better understand how they get divided. So your defined contribution plans, I'd say all the fours, the 401k, the 401a, the 403bs, the 457s, your profit sharing plans, your employee saving plans, your employee stock option plans, KEO plans, money purchase plans. These are all defined contribution plans. So the employees are making a defined contribution into the plan. The employer may be contributing to that plan as well, but we don't know what the future value is going to be. And these are typically, as you all know, they're separated out, majuscus, and a percentage, plus and gains, minuses, etc. Your defined benefit plan, however, we do have a knowledge of what the future benefit's going to be, and these are your pension plans or your cash balance pension plans. So what's required in a QDRO? And all of this information is information that we're obtaining through the discovery process. And, I said earlier that why I love this area so much is not so much drafting the actual orders, but it's about making sure that when a settlement occurs, all the facts are being considered. And in many cases, the QDRO is a late stage thought process. But the settlement agreement, as Jim mentioned, drives the qualified domestic relations order, or the DRO. And so the information that comes out of the settlement agreement is what we're using to draft the order. If the settlement agreement is not right, because it's not the information in there is not correct, and we draft the order, the plan's not going to accept it. And then we have to go back and we have to make changes to the settlement agreement in order to go back and redraft it and get it approved by the plan. Some of this information may seem easy, but other information may not be so easy to get late stage, especially if the settlement agreement's already been drafted. The easy stuff is the case information, the case number, the court information, participant and alternate payees information. Addresses seem to be, something that tends to be an issue because maybe one spouse has moved. So making sure that we have an updated address is important, because when the plan actually gets the order signed by the courts, they're going to send information via the mail to the address that's in the order. So if the address changes, you don't want the alternate payee's information going to the ex-spouse's house, especially if it's the ex-spouse's plan that's being quadrant. Marriage information, date married, date filed for divorce. This is a big one. The employment and plan information for each plan involved. And I'm going to show you how that can be very misleading. Amount or percentage to be awarded, number of payments or time, and that it relates to either child support, alimony, or property rights to the alternate payee, pursuant to state domestic relation order. And again, the last thing is it's got to be accepted by the plan. Ultimately, as you all know, the plan has the final say. In your settlement agreement, you can agree to whatever terms you come to an agreement in your settlement agreement. It doesn't mean the plan has to accept it. And if the plan doesn't accept it, then we have to go back and get the settlement agreement amended and changed so that the plan will accept it, or else it's not going to take effect. And that's why it's important that we start the process early, because if you know what benefits are available within the plan, and it could be so much as, there may be multiple plans with an employer, and maybe the employee doesn't remember all the things that they have, all the benefits that they have. As a concierge service, what we offer is, if you have a client walk through the door and they or their spouse have a plan, or you think there's a plan and you think there's a chance that a quadro or domestic relations order is going to be needed, that at that very onset that the client walks through the door, we should start the due diligence to determine what benefits and what the plan will allow or not allow. Well, it seems to me like common sense that we want to know that information before you even come to a settlement, because you may agree on something in the settlement that the plan won't allow, or you may not have all the benefits included in the settlement. And that, as you know, could be problematic. And that's where the liability comes into play. When you're creating these settlement agreements, you want to make sure that you have all the information and your client is aware of all the things that they're entitled to as part of the equitable division. Because if you miss something and later on they find out that they missed out on a benefit, or they weren't awarded something that they could have been, they're not going to come to us who draft the quadros, because we're following the settlement agreement. So all of these things that are important about a DRO, a lot of it comes from very early on. And this is what I was speaking about as far as confusion, right? So someone that works at Motorola, yeah, I have a 401k at Motorola, or I have a pension plan at Motorola. Well, which one is it? You can't just, you have to, when we draft the order, we have to be specific to what plan it is. Now, oftentimes this can be taken from the statement. But if someone works at Motorola, just by looking at and this is public information, right? Just looking at the 5500, if you have a client whose spouse worked at Motorola and they only show you a statement or a 401k plan, well, you may not know they're part of the pension plan. Maybe they don't even know they're part of the pension plan, or these other plans that they have available. But it's good in the discovery process to figure out whether or not they are, right? Whether or not you're asking them to provide statements, or, if you have depositions and you want to ask them questions. But if they don't supply this on their statement of net worth, or if they don't put this in the discovery and they don't mention it, and the spouse doesn't know that they have it, then it can be completely overlooked and forgotten in the divorce. But the Plan 5500 helps us to determine not only what plans are available through the employer, but maybe which specific plan we need to cite when we're drafting the order. And as you see here, there are 2 different 401k plans, 2 different pension plans. All of these have different plans that were initiated.
I'm going to just interrupt you for a second and do the first code. The first code here is agree, AGREE. The first code is agree. Thank you.
So an alternate payee. We all know that an alternate payee can be a spouse, a former spouse, a child, or a dependent. An alternate payee is the person who's to receive the benefits via the domestic relations order. And it's for very specific reasons. So if in the settlement agreement, it's not for the specific reason, the plan's not going to allow it. One caveat that I'll say is that most attorneys may or may not know that they can actually get paid legal fees via a QDRO. And there's different case law that allow that, specifically in New York, and very old case law that allows it specifically in New York. But it's always going to be case specific. But typically an alternate payee is a spouse, former spouse, child, or dependent of the participant. So what QDROs cannot do, okay? I mentioned earlier, we can't tell the plan what to do or what not to do. The plan is specific and they hold all the cards. Even a judge's signed order is not going to make the plan do something that they don't have available in the plan. And this is why it's important that we understand all that the plan will allow for prior to generating the settlement agreement. But the plan cannot require to provide any benefits or options that are not available. And there are numerous examples of that, right? So multiple survivors, they may or may not allow you to freeze the plan. If you have concerns over, someone taking money out of the 401k during the proceedings, and you want to stop them from doing it, some plans will put an 18-month freeze on it, but some plans won't. They cannot provide for increased benefits. So different plans allow for a certain amount of benefits to be paid. We can't tell them to pay more than what the benefits are available. Some plans don't allow more than one alternate payee, and that could also be with survivorship. That's the next point here. They can't, you can't require to pay a plan to pay a joint survivor annuity to an alternate payee and a subsequent spouse. So think about a case where, and this is probably, I see this, someone calls me up. I got divorced a few years ago. We were supposed to get a QDRO, it never got done. My husband got remarried. My wife got remarried. I want to get this QDRO done. But now they got remarried and an alternate payee or a new spouse has been named as a beneficiary for survivorship benefits. They retired, and now we can't get the survivorship benefits because they've already elected a survivor for their new wife, and we can't make that change. As you know, the law is not always black and white, and things can be fought out. The point is that it takes a lot of work and going back to court to get these things fixed, if it can be fixed. But just because we submit a new order in based on a divorce that happened 2 or 3 years ago, we can't require the plan to do something that it's not willing to do. Mistakes that lead to liability. And, I hate to say this, but I can almost assure you that the vast majority of you have ticking time bombs in your filing cabinets in previous cases. And I think the reason why you don't see more cases of malpractice is because clients don't know that something was done incorrectly, right? Until if they hired someone later on to review it and address any issues. But today, even today, I just got an order in where there was a big mistake made, right? And I can't say anything because when I'm hired to do a domestic relations order, specifically, divorce happens, I get the order, hey, you were recommended to get this domestic relations order written up. Okay, send me the settlement agreement, send me the account statements. I'm reading the settlement agreements and I see these mistakes. And we'll talk about this in a few, but I'll just give you an example. A defined benefit plan has different benefits to it, like a pension, for an example, may have cost of living adjustments or may have future increases. You don't want to put a specific number down as a payment for a defined benefit plan, because then that excludes the alternate payee from ever getting any increases, right? So if there is cost of living available in the plan, which in this plan there was, and the alternate payee it specified the dollar amount, which is 50% of a payment, and it was that dollar amount is to be put in the order. Well, the alternate payee is only ever going to get that dollar amount. That alternate payee will never get the benefit of the future increases, right? So that's just one of the mistakes that I see. Now, the alternate payee may or may never know that's wrong. But if ever that alternate payee were to go to someone and share with them and they were to address it, that liability falls on the attorney who drafted the settlement agreement. And that's just one recent one. I have other examples in the presentation. But these are the types of things that, again, part of the concierge service, whether it's me or another firm, you want to do the due diligence in advance before having the settlement agreement signed to make sure that these mistakes are addressed and fixed. Because once they're signed and done and we're doing the orders, we can't go to either party and say this was done incorrectly. I can't go to the attorney and say, hey, this was wrong, because then I'm being biased, and that just wouldn't be fair to the other party. And it's sad, but I see it a lot. But incorrect marital determinations, incorrect valuation dates, the big one is survivor benefits not being addressed. And especially if the participant predeceases the alternate payee. Again, in the instance where, let's say you have a settlement agreement that doesn't address survivorship benefits, the couple is divorced, a couple of years later, the quadro has never been filed, and then they're looking to get the quadro filed, but the plan participant passed away, and there's nothing in there about survivorship benefits. If that wasn't addressed in the settlement agreement and the quadro was never drafted, and even if the quadro was drafted, it wouldn't have survivorship benefits in there. But now, the wife or the husband is expecting to get those survivorship benefits, and they're not there. They're gone. That's probably the most costly mistake that can be made. And I know you're probably thinking, well, that's easy. I would never forget that. But I see a lot of settlement agreements, and I see a lot of cases where it's overlooked. Omitting early retirement benefits. So this is a case where you, in a defined benefit plan, like a pension, you say when the participant is, or when the employee spouse retires at age 67, the wife is to receive X amount of dollars or X percentage of the pension. Well, if you're saying that they're going to retire at 67, but the plan allows them to retire early, which you don't know about, and then they do retire early, well, they're retired getting their pension, but the alternate payee's benefit doesn't kick in until they turn 67. So maybe they could have retired early at 62. But now they got 5 years that the alternate payee has to wait until they get payment. So that's why these things have to be addressed prior to. And I keep saying, I don't sound like a broken record, but the point is that you have to know what the plan allows for. So that if the employee is entitled to early retirement, it's, the orders or the settlement agreement is drafted to match the potential for an early retirement, and that the alternate payee will receive their share at the same time that the employee spouse receives their benefits. Another one, just as much as I see settlement agreements that request domestic relations order to be drafted for IRAs, I see ERISA being cited for state plans, right? ERISA has no governing over the state plans, and vice versa. Failing to submit for a quadro at the time of divorce. I understand that once the parties divorce, it's kind of on them to get this done. And in the orders, it usually says within 30, 60, 90 days. But so much can happen whether someone dies, they get remarried, change jobs. I mean, a lot of things can happen, but getting a quadro at the time of divorce and doing it fast as soon as the divorce is been filed is important. And an incorrect division method is another, we'll talk about division methods in a minute. But again, a lot of these mistakes are not identified. And it's because the folks that are receiving or having these benefits don't know that something was done incorrectly. And unless they came to me and said, hey, I got a divorce and this is what my settlement agreement showed. Part of my, expertise as a certified quadro specialist is to testify in court as to settlement agreements and the fairness of them and whether or not mistakes were made. And so, if a client came in and said, can you review my divorce? And that client hires me and retains me to review the divorce, and it would be my duty to say, well, this is what you were entitled to, and this is what was addressed in your settlement agreement. Therein lies a liability. And that pains me more than anything else, because I know that all could have been prevented by doing the due diligence beforehand. So 5 ways to avoid malpractice, even if you don't do quadros, okay? And again, the reality is, just because, and Jim mentioned this, just because you hire someone like me to draft a quadro doesn't mean you're off the hook. And that's because the quadro stems from the settlement agreement. But you want to make sure your retainer agreement clearly states that your representation doesn't include the preparation of the domestic relations order. Getting all of the retirement information during the discovery process as early as possible. Know the difference between separate and shared interest before drafting the agreement, okay, or trying the case. And we're going to talk about these 2 things, but they're very specific, and these deal with defined benefit pensions, whether someone has their own interest or if there's a shared interest. Some plans don't allow for separate interest, but if you require, or if you put in the order, for an example, and we're going to talk about this, but if you put in an order for a state plan that someone wants to have a separate interest and the plan doesn't allow for separate interests, well, we can't get that executed because they only allow shared interests. But so understanding the difference between those. Know the deadlines and retain an expert if needed. Things like military has deadlines. For an example, if you have someone in the military, the quadro has to be done within 90 days of the orders being signed. So in other words, if you have a divorce decree in the military, you have 90 days to get the quadro. The date has to be within 90 days between the quadro and the order being signed. It has to be sent to the military. There's other dates that each plan has that requires things to be executed by. So if you don't know these deadlines and they're not done, the alternate payee could lose out on benefits because of a timing issue. And having the basic domestic relations order drafted at the time of hearing. Again, it's all about being prepared, right? In the military, we used to say prior planning prevents poor performance. So having all of this done before a hearing, if you're going to trial, or having the order done early on, doesn't mean that it has to be filed and sent to the plan and executed. We don't have to put the plan on hold and piss off the employee, but we can have everything prepared so that it's all in sync. I was saying earlier to Barbara that I commit very little things to memory when it comes to dealing with these plans. And the reason being is that, and I don't make any assumptions about any plan. I don't care how many times I've drafted a quadro or a domestic relations order for a specific plan. When I'm presented with the case, I treat it like I've never looked at it before, because plans will change the way they do things. They'll change the way the plans work and what they'll allow, what they won't allow. And they don't notify us and say, hey, by the way, we've changed this, so the next time you have an order come through, just be updated. And there are so many different plans out there that it's impossible to stay on top of them all. So, you know, what the plan did yesterday does not mean the same is going to happen today. So every plan, every single divorce, every single case, I treat it like it's the first one, and I look through it granularly to make sure that I understand what's available and what's not available as of the date that we're doing the orders and deciding the separation. One big thing I will say is that, you know, for when it comes to valuating like a 401k or 403b, TIA, right, will no longer accept an order with a date in the past as a valuation to calculate the present value as a data segregation. So what do I mean by that? Let's say you have someone who got who data commencement was June of last year. And now we're in, so that's June of 23. We're in January 24. Data commencement. I know that's a quick marriage, quick divorce, but let's just say it happens. And now we're looking to make the separation and we're evaluating that. Well, we have to come up with, TIA will no longer say, okay, data commencement was June, and they won't calculate the market forces, the gains and losses up until today, and then divide the percentage. We've got to provide them with a number. So it used to be you would just write in the order, you know, spouse received 50% as of this date, plus and minus gains and losses up into the data segregation. And that used to be fine. And a lot of plans will do that. But more and more plans are following TIA's lead and no longer doing those calculations. So what does that mean? That means that if we send in an order that says exactly what the settlement agreement says, they're going to kick back and say, sorry, we're not going to do the calculation. So we've got to provide them with a specific number, which complicates things a little bit, because then if that couple came to me today with the order, I'd have to tell them, well, look, we have to pick a definitive date to finally value this account. And I have to do the valuation as to what the market forces were, especially if that person is still working and contributing to the plan. We have to exclude the employee's contributions and the growth and or losses on that and determine what the marital portion has been. And then we have to come up with a number and then tell the plan how much money to give. So it requires the couple to agree on a second date of segregation, essentially. And then we have to provide a specific dollar amount to TIA. And more plans are going this way because they want to shift the liability off themselves back onto us and not be the ones to say, you know, this is the evaluation and them putting themselves at risk of being wrong. So that's a big change that happened last year. Eaton Corporation is another one. So you're seeing a lot of these big custodians that are stopping to do that. And if I can further complex the situation, TIA has multiple plans. Like everybody knows that the teachers of many universities use TIA. And, you know, there within that, you have every university has a different plan. And every university has multiple plans. And they're all, the TIA is the custodian for the majority of them. And what's crazy is that you may have one, like Columbia University and the University of Texas. They're both TIA. Columbia will not do the valuation, but Texas will. So it's absolutely crazy what's happening and the changes. But the point here is you can't assume what the plan will and won't do. And again, I go back to prior planning prevents poor performance. If we know this into advance, then you can build into your settlement at this date, the plan will have to be valued and this dollar amount will be awarded to the spouse because they're not going to do the math. Barbara, did you need to give a code?
Yep, I'm just going to interrupt you again. I also want to remind people, if you have any questions, you can put them in the chat. So the next code is divorce. The code is divorce. Please put that on your form when you send it to me. Thank you.
You know, I just like to ask for like a kind of like a midpoint checkpoint and how I'm doing here. Is this making sense to everyone? Is it foreign language? You know, a thumbs up, something just to let me know if this is, you know, so far beneficial. I don't see any questions coming in, So either I'm boring you guys to death or I'm covering this really well. One of the two are happening, but you know, this
I
is
see a
meant to be
thumbs up.
interactive. Sorry.
Andrea's giving a thumbs up.
Thank you very much. Thank
I'm
you.
actually on the line with my malpractice carrier right now. Just, but I am listening though. It's good. It's good.
All right. So we do have a question. I'll read the question. In the situation you described with TIA, where you need to include the dollar amount rather than rather than based on dates, do we know where the NYPD is on that? So no, I check everything. And again, this is a good situation where if you call me up, unless I did one yesterday on that exact plan, I'm not confident to say that I can give you a for sure answer. I will double check and let you know. But you know, and every plan is different. And just so you understand that, again, NYPD, I don't know if I've ever seen NYPD with TIA, but in any case, it doesn't matter who it is. You know, it could be yesterday, they determined as of yesterday, they were no longer going to do it. So I treat every case as is a brand new case. But this is something that, again, this shouldn't be a bottom of the ninth inning type of determination. We should know this way in advance so that there are no surprises and there's no knee-jerk reactions to the settlement agreement. We know this way in advance what we're dealing with. I think the biggest thing is not only knowing what we're dealing with, but also what benefits are available. And the other thing I'll say to you is that, you know, people forget about things. When the discovery process or the intake process occurs, you know, I like to find out all the employers that either spouse has worked at during the marriage. And why is that? Well, because there could be plans at those old employers that they genuinely forgot. You know, truth be told, I had many years ago, one of the employers I worked at had a cash balance plan. I completely forgot all about that. And one day I get a statement from Prudential about, you know, a cash balance plan with money. And I'm like, what is this? I genuinely had no idea about that plan that was from so many years ago. And I can assure you that people who have long duration marriages who've had multiple employers probably don't remember all the plans they have. You know, they come in and they have multiple 401ks because they worked at multiple employers. But did they have any other benefits at those employers? And that's why, you know, doing the due diligence in advance is important. We can contact those employers. We can get all the benefits that they were entitled to, right? Some plans, believe it or not, when it comes to sick pay and vacation pay, you know, if the person retires with that, let's say someone accumulated sick pay or vacation pay while they were married. Well, do you know that that should be calculated into the pension, especially if they're allowed to credit sick pay and or vacation pay towards their pension, the pension for credits? So, you know, these are all the things that get overlooked. You know, if someone never took sick time or never took vacation and they racked up all this time, and that can buy more credits for their pension, and that was all accrued marital, then, you know, that can be completely forgotten about. We don't know that unless we go to the plan, because I guarantee you, you know, most people don't know their own benefits and they're not going to know something like that. And if it's the opposing spouse, they're probably not going to volunteer that information. And they more than likely don't even know that it exists. But that's just another example of finding everything out beforehand. So valuations, you know, prior to 2014, let's see here. What language, we have a question. So what language should be put in the settlement agreement that deal with the TIA issue? So the language that I would suggest is, you know, I would come up with a defined date. So when I'm working with couples, I usually leave it up to them. So let's say I get an order and it's a TIA plan, and the plan is not willing to do the valuation. I usually tell both parties, because I only speak to them together. I never speak to any one of them without the other one. I keep everybody in the loop. I usually say to them, look, we need to come up with a date. We need to come up with a date. We can use today's date. We can use the last statement date. We can use the next statement date, whatever it is. We need to come up with a date to finally value this, to come up with a number. So, you know, that language would be, you can even put in there, you know, this plan will not calculate the gains and losses up to date of segregation. Therefore, the parties agree to use this date as a date of value for segregation. You know, something to that effect. And by the way, you know, don't be scared to reach out to me and say, hey, can you help me with the language in this agreement? Because that's something I do quite often. A lot of my law partners will reach out to me and say, can you look at this settlement agreement and tell me if my language is good or not? You know, and I don't have a problem doing that. And making sure, because at that point, and again, I hate to do it last minute because it is last minute at that point, but then I go and I look at the plan. You know, a lot of plans will offer modeled orders. So that's the first place that I go. But the other thing is I try to make sure that all the benefits are being covered and discussed. But if the settlement agreement is already being drafted, it's probably too late to go back and reopen. Hey, you know what? There were plans that were not discussed and we got to reopen this. It can make it very sticky. But so I hope that answers your question as far as what language. I would just use a specified date for value for segregation. And that would work. So if that doesn't answer your question, let me know, but I believe that'll work. And I know it has to be fine-tuned. I'm just kind of giving it to you off the top of my head, but it will definitely be more legalese in the actual agreement. So when it comes to valuations, back to valuations, and thank you very much for the questions because they help contribute to the presentation. When it comes to valuations, there are certain assumptions. Now, before 2014, valuations were all over the board. There really wasn't a standard way to value. And when I'm talking about valuations, I'm speaking about pension plans, defined benefit plans, which is, you know, the sum of all future payments and what that value is today. Typically, the valuation, and this is what the hard thing that most people, you know, when I talk about valuations with clients, you know, it's a hypothetical. Even with the actual standard 34, which was put together after 2014, which standardized, you know, what ways to value these types of pensions. You know, if you put two experts on the stand, you're probably going to get two different numbers. And it's, you know, usually the court will, you know, split them down the middle, provided that both arguments are justified. But the underlying assumptions when you're doing the valuation is a discount rate. So quick math here, you know, a discount rate is kind of the inverse. If you think of an interest rate, a discount rate is the inverse of an interest rate, right? If you want to think about how your money is going to grow in a bank account, you earn an interest rate. Well, the discount rate is taking into account what rate you can grow that money, right? What interest rate will you need to grow that money over the next 20, 30 years? Therefore, we have to apply that as a discount to bring the value today, right? So let me try and explain this a little bit better. You have an account that's going to pay, let's say, we'll keep it real easy, right? $1,000 a year. And based on the mortality tables, that person is going to live for another 30 years. That's $30,000. So that's the future value. But what's the value today? What do you need in an account today to achieve $30,000 in 30 years? You don't need $30,000 today because you can get a rate of interest today compounded over the next 30 years to achieve $30,000. So the discount rate, typically I use the 20-year treasury, right? This also comes into play when you're doing like maintenance buyouts, right? Like, so someone's going to be ordered to pay maintenance and they want to buy it out. Well, you know, how much are we going to discount the future sum of all payments to today to determine what's needed in an account today to achieve the same amount over the same period of time? So the discount rate is important. Now, the discount rate could be specific to the plan, or I use the risk-free rate, meaning that there's no risk to this rate, assuming that the U.S. treasuries are the most secure and safest investment in the world, the 20-year treasury rate is typically what I use as a discount rate. Cost of living, right? So if most plans typically have something tied to the consumer price index or the CPI, but they're usually capped between 1% and 3%. But if there's going to be a cost of living applied to the pension, you have to determine, and you don't know what's going to happen in the future, right? Just like with interest rates, you don't know what interest rates are going to do in the future. So if current interest rates are high, you're basically imputing a very high discount rate, which is going to lower the present value, right? If current interest rates are low, it's going to impute a low interest rate over a long period of time. So it's going to impute a higher current value. But if interest rates change, that valuation can be completely off. Because if interest rates today are 4%, it's going to bring a lower present value. Well, if next year interest rates go down to 2%, that same valuation today would have been higher. With cost of living, the same thing. We don't know what cost of living is going to be and what the plans are going to put on the pensions. So cost of living, the plan itself may say they use 1 to 3, never less than 1, never more than 3, but it's the CPI plus 1. Or they have their own way of figuring it out. Well, when we do evaluation, I usually take the median. Okay, if the low is 1, the high is 3, I'm going to use 2. So I'm going to use 2% as a cost of living increase. Now, mortality tables, there are 6 tables under the actuarial standard 34. The one thing I'll say is when it comes to mortality tables, I use the same mortality table for everyone. And because if I'm ever on the stand being questioned, I never want to be questioned on why I use this table for this case and not the other cases, and vice versa. So the mortality table that I use basically tells us, how long someone's going to live for, presumably based on the mortality tables. And the retirement age. When are they going to retire? One of the things that I find is that when it comes to valuations, we have to I value anyway, based on the earliest retirement age, because we can't assume somebody's going to work to 67. If they can retire at 62 or they can retire at 55, then I value the pension based on the earliest date of retirement. Now, if you have a younger person with a longer period, right? So if someone retires at 55 and the mortality says they're going to live to 90, that's longer payments. Chances are you're going to have a higher present value because you have a longer period of payments, albeit lower. If someone retires later, they have a shorter lifespan, maybe getting a higher payment, but because they're living a shorter lifespan, you're probably going to have a lower present value. And the pension estimate payment. Now, this is where a big mistake is made, because when it comes to the payments of the pensions, many times when you're looking at a statement, the statement is giving you a hypothetical as if the person were to work to this age and giving you a hypothetical amount of income. Now, New York is known to give a pro rata share, so it's kind of beneficial to the alternate payee, meaning that they use the value at retirement. But it can be argued that if you have somebody that's worked somewhere for 10 years and their pension is going to be based on, the past 36 months by some formula, you probably safe to assume that if they're getting divorced after working somewhere for 10 years, but they're going to put 20 or 25 years in, their better years have yet to come. And a pro rata share, that means that the alternate payee is probably going to get a higher payment than they would than if we used the income that was earned during the marriage. So I've done them both ways. But if you look at if you get a statement, the statements are the worst to use for valuations because they don't paint the right picture. What we have to do is we have to contact the employer and understand what, like, for an example, if I'm valuing a pension, I want to know what the last 3 or the highest 3 years were up during the marriage and utilize that for my valuation as opposed to a hypothetical number. And, I've seen it, and I've argued against other experts that have done it the other way. And it depends on who you're representing too, right? Because if you're representing the alternate payee, this is probably not something you want to argue. You want your alternate payee, the spouse, the non-employee spouse, to get a higher payment. If the other side doesn't catch it, that's on them. You've done a good job for your client. But if your client is the employee, well, you want to make sure that they're not giving up more than they need to give up. And that's very critical when it comes to valuations. But, you know, people, I feel, clients, not necessarily attorneys, but clients, take to heart the valuations that are provided when we're valuing pensions. And I can't stress that it's really only used to offset. But there's so many hypotheticals built into it that, you know, it's a very slippery slope when utilizing that valuation. And just as much as I can argue for, I can argue against any valuation. But it has at least gotten better with the actual standard 34, because at least there's guidelines that have to be used. But pension valuations, you know, they're not as easy as one may think. And there's a lot of areas where mistakes can be made. You know, I got a case in Jersey not too long ago where I was the third-party expert weighing in on the two valuations done by two very big companies. They've been around for a very long time. Everybody knows their names, and I won't say it. And both companies made major mistakes in their valuations. And I pointed them both out and came up with a third, and my valuation stood against the two companies. One used a discount rate that was way unrealistic, and the other one had the wrong retirement date. So the one valued the pension based on the retirement date of the latest date that the person can retire and not the earliest date, and that was a mistake. And the other company used a discount rate of 7% because they read that the pension earned 7% on their investments. Well, that's not necessarily where you get the discount rate from. So these things can happen and mistakes can be made. And especially if a client is using this to offset other assets, you definitely want to make sure these valuations are done correctly. So determining marital portion, right? So there's two ways when we're looking at plans to determine the marital portion. You have the coverage fraction, the fractional rule, or the direct tracing rule. And I'm just going to show you, I mean, we all know what the coverage fraction is and direct tracing. You know, I don't have to explain those to you, but I want to show you the differences here. So this here, years of service, right? So the plan provides a retirement benefit equal to 1% of the final year's compensation multiplied by years of service. Accrued benefits vest after 5 years of service. I'm just reading this off to you. Early age at 55. They have completed 10 years of service. Normal retirement is 65. The covered party joined the plan at age 25, got married at 29, and age 40 of the allocation date, right? So the covered party's historical service compensated accrued vested. That's typical of what you would see in a plan. So when you're doing the coverage fracture and you're looking at this, we would take, you know, the total amount in the plan, determine what the years married were, do the division, and this is what you get as far as a breakdown, right? So based on accrual of service, here is the total time in the plan is 3630. Based on compensation, take the total marital compensation divided by that. So that's what they get, 4068. So we use the mortality tables, discount rates, cost of living, estimated payments to determine the present value of the pension, determine the marital plan. So what this is just basically saying is that you have the coverage fracture, which is taking the entire period into account, and then looking at the marital time, and then figuring out what the coverage fracture is. The direct tracing method, right, basically says that if they have 4950, they were married at 29, so anything prior to that is eliminated, and what's marital is the time married, and so therefore we would deduct 580 from the 4950, and we would get 4370 as accrued marital benefit. The point of this between the coverage and the direct tracing that I'm trying to illustrate to you is that depending on who you are representing, you may request two different methods. Why? Because if you're representing the non-employee spouse or the alternate payee, and this person made most of their money and most of their credits while they were married, then they would get a higher benefit by using the direct tracing method, because they're going to benefit from the higher income earning years, as opposed to the coverture, which would give them a lower benefit because you're taking into account all of the years. So if you're representing the employee spouse, well, the coverture method would work out because the alternate payee is going to get less. But if you're representing the alternate payee, you may want the direct tracing method because they're going to get more. Neither method is wrong or right. It just depends on who you're representing and what you want to achieve. It could also be that, they're very early on in their career, then it may not make a difference. But for long duration marriages or marriages where the party is older or maybe more seasoned and more veteran in their career, it may make sense to do the direct tracing method, because then we eliminate all the lower years. And if you get rid of all the lower years and you're just using the higher income earning years, chances are you're going to get more marital value from that. So that's the big difference between direct tracing and coverture, because I don't want to get into giving you guys a math class. That's my job. But just understanding that there's a difference in the way and the methods that these can be done. It all depends on who you're representing and what you want to achieve and what makes sense. You certainly don't want to go for the direct tracing method if it doesn't benefit your client. Chat box is quiet. No questions. All right. So we talked about when there's a defined benefit plan, two different forms of alternate payees can get paid. Okay. What's important to understand that some plans don't allow separate interest. So separate interest basically means that when the plan is served the domestic relations order, they essentially carve out a non-participant pension for that alternate payee. So they basically say, okay, we're going to take so much out of this person's plan and open an account for the alternate payee, and we're going to give them their own separate interest, their own payment, as opposed to think of a shared interest almost as if you were garnishing someone's wages, where the shared interest means that they're getting a piece of that person's paycheck. Now, why this is important? It's important because with the separate interest, if survivorship benefits are not to be awarded, and you can get a separate interest, that means that the separate interest pays out regardless of what happens with the employee spouse. Because once the quadro's been put into effect, that alternate payee now has their own pension. So I know it's not nice to say, but the employee spouse can die. If anything can happen, that person's getting a separate interest. Their interests are protected. They're going to continue to get their benefits. Now, the one thing that I'll say is that be wary of this, because when that happens, the payment may not be equal to what the employee spouse is earning. Why is that? Let's say you have husband and wife, and the husband's the employee spouse, and the husband is older than the wife. Well, we talked about mortality tables. So the husband's payment may be a certain dollar amount based on his age because of the mortality tables, right? That's how pensions work. It's kind of like Social Security. They know how long a person should live, and that's how they dictate how much needs to be in the pension to pay out those payments over the lifetime. Well, with a separate interest, if the wife is younger, chances are her payment's going to be less because she is going to live a longer period of time. So she's not getting less money, but she may get a lower payment because based on the mortality tables, she's going to live a longer life. And that's something that your client should know. you know, just because your husband's entitled to a $2,000 a month payment and you're going to get 50% doesn't mean you're going to get $1,000. Because if that wife is younger, it could mean she gets $800 for the rest of her life. And that's important to know about the separate interest. Also about separate interest is that most state and government plans don't allow it. So if you have a New York State or a government plan, chances are you're not going to get a separate interest award. It's going to be a shared interest. So a shared interest, as I mentioned, is based upon the life of the participant. Now, that just basically means that the payment received by the participant is split in half. So if you have a shared interest and the payment's $1,000, and using the same scenario, the wife is to get 50% of it, she's going to get $1,000. So the husband gets 1,000, she gets 1,000, total payment $2,000. If there was a survivorship addressed, then you have to determine who's going to pay for that. And there's several ways you can do that. So, for an example, if a wife is to receive survivorship benefits, meaning that the pension payment is going to be less, well, that's like a life insurance policy, right? I mean, think about it. If to insure a certain dollar amount, people buy insurance, life insurance, right? Someone dies early, they buy life insurance, it makes up for the income they would have brought in over their lifetime, their human capital. So when you take a joint survivor annuity on a pension, it's the same thing. So if the wife is requesting survivorship benefits, that's going to reduce the payment. Well, we have to determine what the value of that reduction is. And if the wife is going to be, like, for an example, if I'm representing the party that is the participating spouse, then I would say, well, if the wife wants survivorship benefits, she should pay for it. Now, just because the present value of her survivorship benefits is $150,000 doesn't necessarily mean she's got to come out of pocket with $150,000. She could, if she has the assets, but we can just reduce her percentage to make up for that $150,000 difference. So she's maybe not getting 50%, maybe she's going to get 45% of the shared interest because she wants the joint survivor annuity. If I'm on the wife, I'm not saying anything because why am I going to make the other side's life easier? But these are the things that we see. But shared interest, almost always when you're dealing with state plans, that's what you're going to have. And just bear in mind when they have the joint survivor annuity, the wife may be getting, while the participant spouse is alive and the pension's being paid out to that person and the wife is receiving 50% or whatever percent that she's receiving, they're each getting $1,000. Now, if the husband dies, the wife now receives the full payment of $2,000 or whatever the amount is for survivorship, assuming that $2,000 is the reduced amount for the survivorship benefit. The wife would receive the $2,000. She would no longer get the $1,000. She would get the $2,000 if the husband died, and that's what she's paying for. So that's important to know between separate and shared interest. A lot of information. Any questions on that?
I just want to interject real quick with the time that we have left. We're going to have some time for question and answer. I know sometimes people are reluctant to post questions to the group chat for fear of either A, being thought ignorant. I know I always feel ignorant when I hear Jay talking, or B, your adversary is also on here. You got Sue yelling on the other side and she's watching. You don't want to ask a question that then she's going to know the question that you ask because she's your opposing counsel. Sorry to pick on you, Sue. If you want to ask a question privately in the chat function, just change from meeting group chat to me individually, Jim Sexton, or to Jay, and only he or only I will see the question. And then we can mention the question and Jay can answer the question without attributing it to anyone in specifically. Thanks. Sorry to interrupt you.
Yep. All good. So this is just an example here of what it looks like when we split it up, right? So if the wife, when we're looking at a separate interest, right? And this is if there's a single life only annuity here, the wife is going to get $400 in this case versus the $500 because she has a longer life expectancy. If your client is expecting to get the same amount as the husband and she's younger or he's younger, they're going to be upset when they get a lower amount. So it's important that they understand that that's going to happen. So the wife in this situation gets $400 versus $500 because she has a longer life expectancy. Remember, pensions are determined based on age. So when they create a separate interest for the wife, she's younger, they're going to recalculate the amount awarded to her based over her lifetime in the mortality tables. If the wife dies first, right? Her amount forfeits in the plan. The husband retains $500 a month. Why? Because they've carved out two different pensions now. They're two independent pensions, right? So if the wife dies, basically the money that wasn't paid out to her, and that's the way pensions work, right? Some people will live long, some will die young. Those that die young pay for those of people that live long. So in this scenario here, the wife's amount forfeits to the plan. The husband maintains $500. The husband dies first. His portion forfeits to the plan. The wife continues her payment of $400. Mind you, there's no survivorship in this. Okay? This is a separate interest. In this scenario here, right, there's a 50% joint and survivor annuity. Okay? So the total payment, now this would be considered a shared interest because you have the joint and survivor annuity on there. So the total payment is $900, $450, $450. If the wife dies first, the wife's payment reverts back to the husband, right? So now he's getting the $900 a month, but because they picked 50% of the total award as a survivorship option, the wife continues to get $450, which is just coincidence because, you know, it's a 50% joint survivor of the $900 payment. So it just happened. If they collected, if it was 100, it'd be a different number. And here's the 100. This is exactly what I was just saying. So $850 with 100% joint and survivor annuity. They're split in $425. The wife dies first. The husband gets the $850. The husband dies first. The wife now gets the $850, right? The question is, that's $150 a month that's being lost in benefits. Who pays for that? And depending on who your client is, you may want to address that. I got to tell you that 9 out of 10 plans, I would say 9.5% of the plans I see this is never, I see survivorship, congratulations, because I see survivorship addressed, but I don't see who's paying for it addressed. So we have some questions here. How do you tell if you can do a separate interest? That's a great question. So you call someone like myself to do the plan research, unless you want to take the time out to do the research on the plan. You know, real quick here. So part of the concierge services that I provide, and I'm not, it's not like a selfish plug, but we have a concierge service where the employed spouse signs a waiver. Basically allows us to go to the employer. We present the authorization to the employer and say, your employee signed this, allowing you to give us information. And then we have a questionnaire for the plan. And it's like a 2 to 3 page questionnaire. And then that questionnaire, the plan administrator will fill in and give us all the answers that we want. They'll tell us all the plans that they're involved in. They'll tell them what benefits are available. They'll tell us when they can retire. They tell us all the information we want. That's the best way to get the information right from the horse's mouth. So many cases hang by a thread of information, and sadly, settlements are arranged on that thread of information, which may not be all accurate. And again, it's because the people who are divorcing know less than the attorneys that do this, and therefore the issues are never brought up, and they just assume that they got what they should have gotten and they don't challenge it. And that's why I think that there are a lot of people out there that don't realize that it was done wrong. All right, I'm just reading some of the commentary in the chat box. So again, shared interest, 50%, we covered this. The big question is, who pays for that reduction? And is it fair that the wife should pay or the husband should pay if they're going to get the joint survivor annuity if the employee spouse passes away? So, you know, the new math, which I don't understand at all. You know, I have 3 adult children and I went to school in the 70s and 80s. And, you know, there was one type of math back then. My wife has a 13-year-old and they have a whole new math, which I have no idea. But, you know, in the new math, to those of you that know the new math, this may look correct, but it's wrong. And I'm going to show you some examples of wording and settlement agreements where the way it's written has a direct impact on what happens in the actual order. So this is how it was. The petitioner's Wells Fargo retirement account through her employer shall be divided by qualified domestic relations order as follows. Respondent shall be entitled to half the value of the retirement plan as of the date of divorce minus approximate balance of the retirement plan at the time of marriage plus of the parties, which was $50,000. So if you read this, and I'm reading this, it's $250,000 divided in half gives me $125. Then a credit of $50,000 leaves $75,000. So that's what the non-participant spouse is going to get. However, the intent was different. The intent was to split the marital half, giving credit to the wife for $50,000. So they wanted to split the marital portion of the account. They decided to credit the husband with $50,000 balance. So the math should have been 250 minus 50 leaves $200,000. Therefore, splitting that in half, each party gets $100,000. If this is your client and they're expecting $100,000, but the order, and this is a real order, by the way, I didn't create this. This is a cutout. But this was, and the problem is this, and I'm guilty of it too, is that I know in my mind what I want to have happen, and I write it out. And I try to cover all my bases by putting all the information in there so nothing is left unturned. But then I write it out, and then I read it a bunch of times, and I say, yeah, this makes sense. Your clients read it, and they're like, yeah, we're splitting it, and they're getting credit for 50%. That's exactly what we want. But then you get the third party who's actually executing this, and they read it, and this is how they do the math. So the alternate payee gets $75,000 when they should have gotten $100,000. So who's going to pay that $25,000? The attorney that wrote this is got to come out with that difference. Or I mean, if the quadro's already effectuated and no one catches this, and the client gets a check of $75,000, they're like, wait a minute, I was supposed to get $100. I mean, sure, we can try to back it up and try to get it redone and issue another quadro for $25,000. But what kind of mess is that going to create? I'll leave that for you to decide, but it's not pretty. But this isn't how important the wording could be wrong. All of the numbers are the same, but the way the words are and the sequence of events and the wording significantly changed. This could be very easily $250,000. It could be $2.5 million. I know some of the clients that you guys have and some significant net worths. So this could very easily be $250 or $2.5 million as a mistake. You know, $25,000, you know, Jim probably has that in his pocket right now. But $2.5 million, you know, maybe not.
No, sorry.
The other thing we're going to talk about is planned loans. You know, again, we don't know. I mean, I know that we all we all have the faith and belief in our clients and the opposing party. They're going to do what's right. True story. Real quick, and I'll make it quick. The bottom line was, couple got divorced a couple of years ago. Husband got diagnosed with cancer and decided that he was just going to take all the money out of his 401k before the quadro was affected, right? And it was taking him out of his loans and withdrawals, and and we had to go back and redo it, and it was a nightmare. Another reason why quadro should be effectuated immediately and done quickly and not just forgotten. But plan loans in general, we're either going to include loans or we're going to exclude loans. And this has always confused me when we talk about including and excluding loans, because it's almost like, you're excluding and including opposite. But what this means is this, right? So if we're going to include a loan, let's say this married couple here, Rich and Michelle. Rich has a plan which has $100,000 in it and has a loan for $20,000. If we're going to include it, that means that we're going to include the full amount, including the loan for division, which means at the end of the day, Rich is going to eat that loan of $20,000 and Michelle is going to get $60,000. So Rich is going to be left with $40,000 in his plan and a loan of $20,000, and Michelle is going to have $60,000. If we exclude it, then basically we're just dividing the $100,000. Okay. And then Rich and Michelle are each going to get $50,000. Rich is going to be stuck with the loan, which he's going to pay back. A lot of this has to deal with the purpose of the loan, right? So why was the loan taken out? If it was a marital, then they should both be charged with it. If it wasn't marital, if Rich decided that, he was going to go out and take a trip or buy a fishing boat, or I don't know, whatever reason is non-marital that we can come up with, and we only want to charge Rich with it, well then, we would include the loan and Rich would be responsible to pay back the loan, and Michelle should not lose any money because Rich decided to take out that loan. But if it was a marital, like they wanted to consolidate marital debt or something like that, then we would exclude the loan balance. They would each share in the amount that's available. But because Rich is going to be paying back the loan, because mind you, non-employees can't pay back a 401k loan. So if Rich is going to be paying back the loan, then he's got to pay back the loan of $20,000, but they each share in $50,000. So this has always confused me, and I always have to think twice about it when I'm talking about it. But it's all very possible to happen. That brings us up to our Q&A. A lot of information, and I know we took a lot of time. We allotted for an hour and a half. We're in an hour 20. We went over a lot of information. And as I said, a lot of these things are changing on a daily basis. For those of you that I've worked with in the past, I appreciate you jumping on today's call. For those of you who haven't worked, I like to consider myself as an ally. Yes, I'm in business, but, sometimes relationship transcends business. And if you need help or if you have questions, feel free to reach out and call, and I'll do my best to help you as much as I possibly can. Because it's the relationship that matters most to me, not so much the business. The business, I think, is a side part of the relationship. So with that, I'll leave it open for Q&A, and I hope that you all were able to at least get one or two things out of this that will help you in your practice.
Let me just get our last code here. The last code is PLAN, P-L-A-N. Last code is PLAN. All right, Q&A away now.
So I like those code words, right? Agree to have Jay help plan for your client's divorce.
There you go. And that'll help you remember the codes if you didn't write them down.
I love it.
Well, we only have a couple more minutes, but if anybody has any other questions, there really are no stupid questions. There are inquisitive idiots, but there are no stupid questions. So please feel free to take advantage of Jay's time while we have it. We have a couple more minutes here. I certainly want to say on behalf of the whole matrimonial bar, Jay, not that I can purport to speak for them, this is incredibly helpful, terrifying, but incredibly helpful information. This is a complex topic, and you really helped boil a lot of it down. And I do want to say, at the risk of seeming like I'm endorsing Jay too heavily, Jay is sincere in his statement that if you have a question, if you have a vexing issue, if you have something that you're just not sure if you're doing it right or how you should be looking at it, he's a very responsive guy who you can reach out to, even if you aren't using his services on that particular case. That's how I met Jay, was reaching out to him with a question. And since then, on other matters, you know, I've been very happy to work with his firm. So I would encourage everybody to take him up on that offer to be a resource for all of us. Because as you can see from today's program, they're really this is a level of understanding he has of these issues that most of us in the matrimonial bar don't have, and it would be amazing if we did have. But it's nice to have Jay. No questions. We have 1 minute left. That's how comprehensive you are, Jay. That, or everyone's just sitting here going, oh my God, I don't understand any of this.
I don't know what it is either. Oh, we got one, hopefully. I will sleep tonight. Thank you. Is that because now you know you can call me, or because you've been doing everything well? That's the question I have.
Well, I think the interesting point you raised, Jay, is that a lot of us don't know where we've had issues or errors. And when the other side drafts a stipulation, you know, every time we make a change to that in the red line, we feel like we have to justify the reasons for it. So yeah, I agree with Daniela when she says, you know, the fact that we know we can call you and have you as a resource, I think that's really helpful. So we appreciate it. I see it's 2 o'clock, which is the end time for this program. Jay, I want to thank you again for being so generous with your time with the bar. We really appreciate it. I want to thank everyone who attended today. You know, we have a lot of interesting and exciting programs coming up in 2024, a lot of them focused on matrimonial practice. This was a very, very specific one, but it was what we knew it would be, a really, really useful one for matrimonial practitioners. But we have some great programs coming up in 2024. As a member of the CLE committee, I'm trying to steer as many matrimonial things as possible, because I like to plan programs that I'd like to attend. So thank you to everybody for coming today. We appreciate you being here and supporting the Bar Association.
Thank you, everyone.
Thank you. And thank you, Jay. Bye-bye.